today. As mentioned during our virtual discussion, there are 12 agencies of our government that use alternative dispute resolution. 10 of the agencies are administrative agencies with quasi-judicial function. One is a private agency, and the one is the barangay, which is our subject matter for today. For review purposes, okay, when we talk about alternative dispute resolution, we are referring to a procedure or process of resolving a dispute other than court adjudication. So in 1978, President Marcos decreed the formation of Katarungang Pambarangay or community-based justice system or barangay justice system by virtue of Presidential Decree number 1508. So this law provided for the compulsory use of every barangay as the smallest unit in our local government of mediation, arbitration, and conciliation in certain types of cases or disputes. So the system was later integrated into our local government code or the Republic Act number 7160, since its discretion and supervision were entrusted to the Department of Interior or local government or the DILG. So what is Republic Act number 7160? As mentioned, Republic Act number 7160 is known as the Local Government Code of the Philippines of 1991. So this law gives barangays the mandate to enforce peace and order and even provide support for the effective enforcement of human rights and even justice. Katarungang Pambarangay or barangay justice, on the other hand, is a system or justice administered at the barangay level for the purpose of amicable setting disputes, okay, through mediation, conciliation, or arbitration among the family or barangay, as I said, without resorting to courts or adjudication. Also, Katarungang Pambarangay is an important system in our barangay to resolve disputes fairly and even speedily. So this is a salient part of our barangays or function to promote peace and harmony, or harmonious relationship among the community members. So this is also in recognition of the capacity of the barangay and its leaders to facilitate the settlement and resolution of disputes at their level or jurisdiction. So under section 399 of Republic Act number 7160 or our local government code, it states that there shall be a lupong tagapamayapa created in each barangay. And when we say lupong tagapamayapa, it is a body organized in every barangay composed of the punong barangay or the barangay chairman as the chairperson and not less than 10 and not more than 20 members, and from which the members of every pangkat shall be chosen. So meaning to say, from this lupong tagapamayapa, the pangkat members or pangkat tagapagkasundo will be chosen. And later on, we will discuss what is this pangkat tagapagkasundo or pangkat and what is their function. And the one who constitutes the lupon is none other than the punong barangay or the barangay chairman being the head of the barangay. So again, punong barangay or the barangay chairman constitute the lupon members in his or her prerogative, meaning to say there is no need for any approval, confirmation, or even ratification of the sangguniang barangay. So what if it is stated in our local government code that there should be a lupong tagapamayapa? What if the punong barangay or the head of the barangay fails to organize the lupon? If that is the case, if the punong barangay or the barangay chairman fails to organize the lupon members, then said punong barangay will be charged with the neglect of duty or even subjected to administrative sanctions. So take note that the barangay chairman will constitute the lupon within 15 days from the start of his or her term as the punong barangay. And he should also notice or issue a notice to constitute the lupon and prepare the list of the names of the proposed members under Section 399, Paragraph C of Republic Act number 7160. So another question, how many members or how many people should the barangay captain or punong barangay should include in the list? So as stated, it is about minimum of 10 numbers or members and a maximum of 20 members. So it's up to you kung sa tingin mo ay okay na yung 10 and basta hindi siya sosobra ng 20 members. Again, it is minimum of 10 members and a maximum of 20 members only. Okay? So, how about the qualifications, okay, for you to become a member of the lupon? So, of course, in constituting lupon, it is important to know who are the qualified members kasi you cannot just appoint a member, okay, without any qualification, okay, without looking at the background or personality of the person, record of the person. So as such, okay, under the local government code, it laid down actually the qualified members of the lupon to include, okay, we can say that he or she is a qualified member of the lupon if that person is actually residing or actually working in that barangay. Dalawa yon, actually residing or actually working in the barangay. Of course, of legal age. And can we say that the person is of legal age? Of course, when the person is at least 18 years old. And also, the person is not expressly disqualified by the law, and he or she should possess integrity, impartiality, or he should possess integrity, impartiality, independence of the mind. Of course, kailangan merong sense of fairness, reputation for probity, and other similar characteristics. So as shown in on the screen, makikita nyo dito who are the qualified members of the lupon and who are the disqualified members of the lupon. Okay? So next up, after identifying the 10 to 20 members of the lupon, what are the next steps? So after identifying the 10 to 20 members of the lupon, the barangay secretary, who is also the concurrent secretary of the lupon, take note of that. Barangay secretary is also the concurrent secretary of the lupon, shall prepare a notice to constitute the lupon using the Katarungang Pambarangay Form number 1. So as shown on your screen, okay? Or nakalagay din yan sa inyong handouts. So take note that this notice, okay, prepared by the barangay secretary, okay, shall be posted in 3 strategic places within your barangay. So, yung kitang-kita. So what is the purpose of posting the same in different strategic places in your barangay? The purpose of which is that in notice kasi, it includes invitation to all barangay members to endorse or even to oppose yung mga proposed appointment of any person listed or included in the list. So the recommendation shall be made within the period of posting for about 3 weeks. Okay, so it means any member of the barangay can protest or even recommend somebody from the barangay. So if they think that this person is not qualified or possesses yung bias, yung hindi siya fair, the person is do not have the sense of open-mindedness, then they can propose or oppose if that's the case. Or if they think na merong mas okay, if there is a person na mas deserving, aside from those who are included in the list, then they can also recommend. And 10 days after the last day of posting, the barangay chairman shall put into writing the appointment of the lupon members, using the katarungang pambarangay form number 2 or the appointment letter shown on your screen, duly signed by the punong barangay and attested by the barangay secretary. So after which, the newly appointed lupon members shall take their oath and immediately, shall take their oath immediately before the punong barangay or the lupon chairperson using katarungang pambarangay form number 5 or the lupon member oath statement. And also, the list of appointed lupon members shall be posted again in 3 strategic and highly visible places in the barangay. So let us summarize the steps in constituting a lupon. Step 1, there should be a determination on the actual number of the lupon members, minimum of 10 and maximum of 20. After which, punong barangay shall prepare a notice to constitute the lupon through the barangay secretary. Next is posting the notice to constitute the lupon. Fourth is the appointment of lupon members, oath taking of lupon members, and another posting. Within the 3 strategic places or visible areas within the barangay. With regard to the term of office of the lupon members, so each lupon member shall serve for about 3 years upon appointment. Each lupon member shall again serve for 3 years unless they are terminated by death, resignation, transfer of residence or place of work, or even withdrawal of appointment by the punong barangay. However, the withdrawal should be concurred by more than a half of all the members of the lupon, including the punong barangay as the lupon chairperson. So it means more than a half. If the lupon members are about 20 in number, more than a half is of 20 is 11. So they should affix their signature there. And for your reference, you may see the thing that is posted on your screen, which is the katarungang pambarangay form number 6. So also, it must be noted that the lupon members shall serve without any compensation. Pero if the barangay has enough funds, they can give honoraria to the lupon members who have participated in the resolution of a particular case. And on a positive note, two daughters or two sons of a Lupon member are qualified to become a state scholar in tertiary education to any state colleges or even state universities under CHED Memorandum Order number 62, series of 1997. Okay? So, next, what will a barangay captain do if there will be cases presented before him or her in the barangay? So how can the barangay captain help in resolving said case or complaint? Take note that the punong barangay has the authority or power to mediate cases of the residents within his jurisdiction. So again, mediation is a process of resolving the conflict with the assistance of a mediator, okay? And the very advantage of mediation is that the decision lies on the disputing parties. So the mediator will just assist, will just facilitate the communication of the two disputing parties. But again, in the end, it is the disputing parties themselves who will make a solution for their problems. Okay? In barangay level, the one who acts as the mediator is the punong barangay or the barangay chairman. And also, there are instances wherein one of the disputing parties or involved parties in the barangay is incompetent or is a minor. So you might be wondering about the process of handling the case. Well, to address that, the incompetent person or the minor shall be represented by a person of legal age or legal guardian or even next of kin who is not a lawyer. So when we say next of kin, it is an individual who is relative or responsible friend within whom the minor is or within whom the minor or the incompetent person lives. Okay? So what are the cases that falls or that fall under the katarungang pambarangay? So all disputes, civil or criminal in nature, where the parties actually reside in the same or municipality or city are subjected to a proceeding of amicable settlement. So there are a lot of cases that actually fall under the jurisdiction of the barangay. So the following are the cases that fall under the katarungang pambarangay. First, we have Article 154 of the Revised Penal Code or the unlawful use of publication. The Article 155, the alarm and scandal, yung kadalasan siguro na reklamo sa barangay, yung masyadong maingay, yan. Pag videoke sa 10 oras ng gabi, kantahan, inuman. Yan. Using of false certificate, Article 175, Article 178 or the use of fictitious names, the Article 179, the illegal use of uniforms or insignias, the physical injuries inflicted in a tumultuous affray, Article 252, Article 253, the giving assistance to a consummated suicide, the Article 260, physical injuries inflicted okay, responsibility of participants in a duel if only physical injuries are inflicted, I mean. So less serious physical injuries, Article 265, Article 266 is light physical injuries and maltreatment, the unlawful arrest or Article 269, Article 271, Article 275, Article 276, Article 277. So napakadami. Meron din tayong grave coercion, that is Article 286, light coercion, Article 287, other similar forms of coercion, the purchase of merchandise and payment of wages by means of tokens, Article 288, Article 289, Article 290, 291, Theft if the value of the stolen property does not exceed 50 pesos. That is Article 309, Article 310. So, napakadami. Meron din tayong acts of lasciviousness with the consent of the offended party, the threatening to publish and offer to prevent such publication for compensation, prohibiting publications of acts referred in the course of official proceedings, incriminating innocent persons, and a lot of cases pa. So for your reference, you may look the cases stated in your handouts or pwede nyo rin tingnan itong nakapost dito sa ating screen. So another question, can the barangay mediate cases involving people's organization or cooperatives operating in the barangay? So the answer is actually no. A juridical person or a corporation like a cooperative or people's organization cannot file actually a complaint because it is not a party to amicable settlement. So any case involving cooperative or people's organization can actually go directly to court without going through mediation or conciliation. So there are other cases that are exempted in katarungang pambarangay aside from the juridical person or corporation. So under Section 408, there are actually there is actually an exemption, no, to the subject matter for amicable settlement. So number one is where one of the parties is a government or subdivisions or instrumentality thereof. So kasi ang general rule natin dito, mga kasama, the lupon of each barangay shall have the authority to bring together the parties actually residing in the same city or municipality for amicable settlement. So as I said, these are the exemptions where one party or where one of the parties is a government or subdivisions or instrumentality thereof. So for example, the ENR, a barangay, or any part of the government. Number two, where one party is a public officer or employee and the dispute relates to the performance of his official functions. So for example, the police officer abuses his power or authority in the performance of his legal duties, then the complaint can go directly to court, no? So next is offenses punishable by imprisonment exceeding 1 year and the fine exceeding 5,000 pesos. Offenses where there is no private offended parties such as gambling and others. Where one of the dispute or where the dispute involves real properties located in different cities or municipalities, unless the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. So when we speak of real properties, we are referring to properties that cannot be transferred from one location to another, such as the land, property, or the houses. Okay. Also, another cases wherein another exception or exemption, I mean, is that such other classes of disputes which the President determine in the interest of justice or upon the recommendation of the Secretary of Justice. Okay? We also have rules to be considered in determining the venue in setting or settling disputes. So when we say venue, it is the place where the case is to be heard and is to be decided. So these are the following rules. So the dispute between persons actually residing in the same barangay shall be brought for amicable settlement before the lupon of the said barangay. So like for instance, Ms. Jose is from barangay A and Ms. Sapuay is also from barangay A, and Ms. Jose filed a case before the barangay captain Mangurnong, okay? So the amicable settlement, since they are from the same barangay, shall be done, no, in barangay A. Okay? So what if magkaiba sila ng barangay, kaiba sila ng location? So as stated, those involving actual residents of different barangays within the same city or municipality shall be brought in the barangay where the respondent or any of the respondents actually reside. So at the election of the complainant or in the choice of the complainant. So another, all disputes involving real properties, tulad ng mga lupa, or any interest therein shall be brought in the barangay where the real property of the larger portion thereof is situated. Like for instance, may pinagtatalunan na real property. So ang mas malaking portion, for example, is in barangay A. So doon magkakaroon ng venue, doon ang venue for amicable settlement. Okay? Next is those arising at the workplace where the contending parties are employed or at the institution where such parties are enrolled for study shall be brought in the barangay where such workplace or institution is located. Okay? So take note, okay? The respondent must raise the question of improper venue in the mediation proceeding before the punong barangay. So pag di niya ginawa yon, the same shall be deemed waived. Okay? So for sample case, you may refer to your handouts or module. Okay? So next is the steps in mediation. What will be the first step in mediating cases? So the complainant, with the help of the barangay secretary, will fill up form number 7 shown on your screen, which is the complaints form, and there will be a minimal filing fee to be charged and paid to the barangay treasurer. So it is also very important to note that no individual can go directly to court or any government office for the adjudication of his or her dispute with another individual, especially kapag yung dispute na yon or case na yon falls under the jurisdiction of the barangay. So except when the parties personally confronted each other and settled their dispute. But if they did not confront with each other and settle their dispute, okay, they should go to natawag nating conciliatory proceedings, okay, or else the court can simply dismiss their case or charge by reason of lack of cause of action or because of prematurity, sinasabi natin. And be noted as well that barangay is not acting like a court. So hindi po sila judge, no? They are not judges. The Lopon members are not judges. The barangay captain is not a judge. The barangay is not a court. Okay? So simply, the barangay chairman or the barangay captain is acting as the mediator. Okay? So and yung pangkat na tagapagkasundo ay tinatawag nating conciliators or conciliation body. Again, they are not also judge. No? So after the complainant has paid the filing fee, the punong barangay within 3 days should issue a notice of hearing to the complainant and summon the respondent, so of whom should appear in his or her office. So what if any of the parties, yung complainant or yung respondent, failed to appear before the barangay captain? So if the complainant cannot appear before the barangay captain or did not appear before the barangay captain without any justifiable reason, then his or her complaint will be dismissed and eventually he or she cannot file a case before the court, and he can also be punished or reprimanded for indirect contempt. However, if the respondent naman failed to appear before the barangay captain without any justifiable cause or reason, halimbawa, hindi siya nag-appear because namatay yung kanyang aso na si Bruno, yan. So his or her counterclaim will be dismissed, no? And he will be barred from filing in court and punished for indirect contempt of court. Okay? So what if naman the complainant and the respondent both appeared before the barangay captain? So the barangay captain, as the mediator, should listen to them carefully and help them find the solution within 15 days. The word is helping them in resolving the conflict or dispute. And if the respondent does not appear, the case will be referred to the pangkat tagapagkasundo or the pangkat. Okay? So before the actual mediation, it is also necessary for the barangay captain to know the parties' differences. Ano yung pagkakaiba nila, okay? Because in mediation proper, mahalaga na explain mo sa kanila yung proseso, the objectives of the mediation, and the rules or policy to be observed during the course of mediation. And in mediation proper also, each party, the complainant and the respondent, will be given time to explain their side without any interruption. Okay? Baka naman mamaya nagmamagaling ka doon. Again, your role only is to resolve or to help them in resolving their conflict or dispute. And also, you may ask questions and involve both parties in looking for the solution of their dispute. Kaya nga sabi natin, it is an advantage on the part of the two parties involved since the decision will lie, the decision will be coming from them and not from the mediator or not from the punong barangay or barangay captain. So as the barangay captain or the mediator, it takes a lot of effort actually, or it is laborious job na mag-mediate sa isang dispute. And it needs a lot of respect, a great deal, okay, and even listening. So remember, in mediation or as a mediator, you are not a judge. Okay? You simply facilitate the communication of the two parties. So let the both parties solve their dispute or find a solution for their dispute. So if the parties agreed, okay, about the case, no, the purong barangay will put into writing the terms and conditions of their settlement in the dialect or language known to them. Okay? So what if naman the disputant or any of the disputant was forced to come up with a settlement through fraud, intimidation, or threat, or yung sinasabi nating FIT. Niloko siya, in-intimidate siya, tinakot siya, just for them to have an agreement to settle. So ito yung tinatawag nating repudiation. So repudiation is the act of rejecting the validity of the settlement or agreement or refusing to accept the terms and conditions of agreement on the ground of fraud, violence, and even intimidation. So if that's the case, any of the party can actually protest the settlement within 10 days before the barangay captain. So after 10 days, at walang ginawa yung isa sa mga disputant, then the settlement will take effect. Okay? So how can the respondent comply with the settlement? So he or she can actually voluntarily comply with the settlement within 5 days. And then however, if he or she fails, then the punong barangay can take his or her property as prescribed by the law. Okay? Be noted also that if the mediation fails, okay, and if there's no settlement that is reached, okay, meron pa bang ibang process or ways for the parties to settle their disputes? So actually, pwede pa and meron pa. Hindi nangangahulugan na pag natapos ang mediation, they can go directly to court for filing of charges. Actually, As I said, there are a lot of ways, no, to help them in resolving the conflict or dispute. So one of these is resolving through a group of conciliators known as the pangkat tagapagkasundo. So that is under the discussion na ng conciliation. So I repeat, no? What if the punong barangay did everything? So pinag-mediate niya, pinag-usap niya yung dalawang parties, lahat ng effort ginawa niya, and hindi sila nag-come up ng agreement. So can they elevate the case before the court? So as I said, still no. The parties still have to go through conciliation proceedings. Ito yung sinasabi ko kanina na body of conciliation or conciliators na tinatawag nating pangkat tagapagkasundo. So again, saan ba kinukuha ang pangkat tagapagkasundo? From among the lupon members. Yung sinabi natin kanina, 10 to 20 members. Okay? So what is the process in conciliation? So as to the process of conciliation, the punong barangay will constitute the pangkat ng tagapagkasundo within 15 days from the last day of mediation proceedings. By the way, to avoid confusion, mediation and conciliation processes are the same. They are the same because the neutral third party only helps the two parties in coming up with a solution over their problems. Except, no, in mediation, it is done by the punong barangay or the barangay captain, while in conciliation, it is being done by the pangkat tagapagkasundo, headed by the pangkat chairperson. So just like in mediation, conciliation is merely intervening between or more contending parties in order to prevent or to end the dispute without an agreement to abide by the decision of the conciliator. It means the conciliator has no decision-making power. Siya yung magro-rule, siya yung magre-resolve over the case or dispute of the two parties. Same lang sila ng nature ng mediation. Okay? They are only facilitators. But again, in mediation, the one who conducts mediation is the punong barangay. The one who conducts arbitration or reconciliation, is the pangkat tagapagkasundo. Okay? So, sino ba ang mga pwedeng maging members ng pangkat? So, take note, again, yung pangkat tagapagkasundo ay kinuha lang natin from among the members of the lupon. And ilan ba ang members ng pangkat? So, 3. Okay? So, the 3 members of the pangkat shall come from the lupon Tagapamayapa, as I said, and will be chosen by the parties, by the complainant, and by the respondent. Okay? So, also, what if the parties fail to agree on the pangkat membership? So, as the lupon chairperson or the barangay captain will determine the 3 members by drawing of lots na sinasabi natin. So, bubunot siya at pipili dito, no, to be distributed to the pangkat, members of the pangkat. So, after the pangkat members have been chosen, ano yung gagawin nila na susunod? So, they shall elect from among themselves kung sino yung tatayong chairperson at kung sino yung tatayong secretary. So, the lupon secretary or the barangay secretary shall now turn over lahat ng records of the case to the pangkat secretary for the pangkat to study. Okay? So, paano naman yung membership ng pangkat? Or ano naman yung rules, no? As to the qualifications of the pangkat. So, similar to the membership of the lupon, we can also disqualify the pangkat member or unfit member of the pangkat. So, what are the cases or what are the grounds? Relationship, bias, interest, or other grounds, no? Baka mamaya ay close friend niya pala yon. So, hindi magkakaroon ng fair and just na proceeding if that's the case. So, also, the pangkat shall be resolved or shall resolve the matter by a majority of vote. So, next, how do we fill the vacancy of the pangkat? If the pangkat disqualifies or if the pangkat decides to disqualify any of its members, then the parties should agree on a common choice for the replacement. So if the two parties fail to agree, the lupon chairperson shall fill the result of the vacancy, tulad ng sinabi ko kanina, by drawing of lots, no? So kapag hindi sila nagkasundo sa pangkat member, no? Nagkakaroon sila ng conflict as to who yung magre-replace doon sa na-disqualify na member, gagawin ni lupon chairperson ay bubunot na lang siya, no? At dito sila pipili ang dalawa. So during the first meeting ng conciliation body and the complainant and the respondent, how does the pangkat proceed with its task? Or what are the immediate goal of the conciliation body or the conciliation proceeding? So the pangkat shall meet to hear both parties and explore the possibilities, no, for amicable settlement within 15 days, which can be extended actually for about 15 days ulit in a meritorious case, and he can also, the pangkat also can issue a subpoena to the witnesses wherever necessary. So in subpoena, the witnesses are commanded to appear before the punong barangay on the specified date to testify in the hearing the case or the dispute between the two parties. Okay? So in conciliation proceeding, what if any of the party fails to appear before the pangkat? So the pangkat chairperson shall actually set a date for the absent of party or parties to appear before him to explain the reason or reasons of his failure to appear at the hearing. So what if after the meeting, nakita ni pangkat na unjustifiable or unreasonable yung reason ng isa sa mga parties. So if the pangkat chairperson finds that the failure to appear of the complainant is unjustifiable, so ang pwedeng gawin ni pangkat chairperson ay una, he can dismiss the complaint. Second, he can actually direct the issuance of and attest to the certification to bar the filing of action in court or any government offices. Apply with local trial court for punishment for the party for the indirect contempt of court. So paano naman kapag yung respondent yung failed to appear na hindi justifiable yung kanyang reason? So yung pangkat, ang gagawin niya, he can dismiss the respondent's counterclaim. Also, he can direct the issuance of and attest to the certification to bar the filing of the respondent ng counterclaim sa any courts, and also to bar the respondent in filing counterclaim in court or government office, and also to file complainant's action in court or any government's office using KP form number 20, or that is the certification to file action. Okay? So next, paano naman kapag yung witness after na subpoena ay hindi siya pumunta di siya nag-appear before the pangkat. So the pangkat chairperson, in the same manner, pwede niyang i-apply, no, yung sinasabi nating punishment na contempt of court, okay, or indirect contempt of court sa isang witness who unreasonably failed to appear before him or her after the issuance of subpoena. So next, what happens naman if the pangkat is successful in the conciliation? So the amicable settlement shall be put in writing in a language or dialect known to the parties. So katulad din sa mediation kanina. But in here, it shall be attested by the lupon chairman or the pangkat chairman. So it has the force and effect of a final judgment ulad ng court after 10 days from the date of amicable settlement was date, unless there is a repudiation na sinasabi natin of the settlement is made. So the secretary or the pangkat secretary shall actually prepare a transmittal of settlement to the appropriate courts or to the appropriate court, and he need to fill up the transmittal form as shown on your screen. So naka-state dito sa transmittal form na dito, the final reports of the settlement of disputes, okay, made by the pangkat tagapagkasundo. So naka-enumerate dito yung mga barangay cases and including the title. For example, barangay case number 1, title of the case, Jose versus Sapuay, for example. Okay? So take note, any of the involved parties in conciliation can actually repudiate the settlement within 10 days from the date of the settlement by filing within the lupon chairperson or pangkat chairperson a statement to that effect sworn before him. So failure to repudiate the settlement within 10-day period shall be deemed waiver the right to challenge on the said grounds. Okay? Again, when we say repudiation, it is the act of rejecting the validity or refusing to accept the terms and conditions of agreement on the ground of fraud, intimidation, and violence. Okay? So next, how can the amicable settlement in the pangkat be executed? So the amicable settlement has the force and effect of a final judgment of a court upon the expiration of 10-day period of repudiation, and this may be enforced by execution by the lupon within 6 months from the date of settlement. So after the lapse of 6 months or such time, the settlement may be enforced by filing a motion in the municipal trial court of the place where the settlement was made. Okay? So, paano naman kapag walang settlement na nangyari between the two parties despite all the efforts to conciliate? Kasi kanina, kapag hindi naging successful ang mediation ay meron pang conciliation. Paano naman kapag sa conciliation, lahat na ng efforts ginawa, okay, lahat na ng sacrifices ginawa, and wala pa rin nangyaring agreement? So ang mangyayari dito, a certification to file action or the KP form number 21 shall be filled up, no? Attesting that no conciliation or settlement has been reached, as certified by the pangkat secretary and signed by the pangkat chairman. So a certification to file action shall be filed to the corresponding court or government office for filing of the appropriate cases. So doon pa lang pwedeng, no, i-certify yung isang complainant for him to file a case before government office or to the court. Ang nakalagay naman dito kasi sa certification to file action is that nakasaad dito na there has been a confrontation between the two parties before the pangkat, and Nagkaroon ng confrontation between the two parties, una before the punong barangay by means of mediation, but it failed. And then nagkaroon ng pangkatagapagkasundo constituted by the barangay captain, but the confrontation between the two parties before the pangkat also did not result to settlement. So therefore, sasabihin dito ni pangkat chairman na the corresponding case or complaint for the dispute ay pwede nang i-file before any court or the court, or government office. Okay, again, the certification to file action is attested by the pangkat chairman. So, next, paano naman kapag nagkaroon ng settlement? How the settlement can be executed? So, the disputant must first file a motion for the execution of the settlement with punong barangay. Then, the punong barangay conducts hearing on the date assigned by the movant, and the date shall not be later than 5 days from the filing of the motion. So after which, pwede nang mag-issue the punong barangay on behalf of the pangkat tagapagkasundo shall now issue a notice of execution na sinasabi mo. So makikita nyo sa screen niyo yung sample ng notice of execution, okay? Issued by the punong barangay. So sasabihin niya kasi dito na on behalf of the lupon Tagapamayapa and by virtue of his power vested on him, okay, by the local government code or by the Katarungang Pambarangay law, so ito na yung gagawin niyang execution for the settlement of the two parties. So next, to summarize, the way of resolving disputes in the barangay is done through mediation, through the punong barangay, and through conciliation, through the pangkat. So at any level of these two proceedings comes another way of resolving cases under the barangay. And this process is known as the arbitration. So ibig sabihin, yung arbitration, pwede siyang mangyari at any stage or proceeding during the mediation or conciliation. So what is arbitration? So arbitration is another way of settling disputes in the barangay wherein the parties agreed to be bound by the decision of a third party or a body. So ibig sabihin dito, sa arbitrator or sa arbitration, merong isang neutral third party or body na didinig sa inyo na kung saan dito nyo i-present yung evidence ninyo, the facts about the case, and then after which, the arbitrator will make an award or decision base sa napakinggan nila or base sa nalaman nila. So, next is arbitration. So, let us discuss or understand further what is arbitration. So arbitration, as stated, can take place at any stage of the proceedings of the mediation and arbitration for as long as the two parties agree in writing to abide by the decision of the arbitrator or the lupon or the pangkat. So it means in arbitration, either the lupon chairperson or the punong barangay or the pangkat chairperson can act as arbitrator. So in mediation and conciliation, balikan lang natin, the lupon chairperson or pangkat simply assist the parties in coming up a solution over their dispute or in their problem. But in arbitration kasi, the lupon chairperson or the pangkat is given the power to render a decision on the dispute with the agreement of the two parties to be bound by it. So the two parties shall present evidence as to the facts and merits of the case to the arbitrator. So as I said, on the basis of these facts, the arbitrator will make a decision on what he or she believes to be fair and just. So in this case, kailangan ang ating arbitrator should be neutral and impartial in making a decision para magkaroon ng fair proceeding between the two parties. So what are these steps in arbitration? So first is there should be a filing of complaint with the office of the punong barangay and the payment of filing fee by the complainant. So if the parties agree to submit themselves to the arbitration process at any stage in mediation and conciliation, magkakaroon na ng arbitration immediately. So after the filing of the agreement of the arbitration, the parties are given 5 days to withdraw from such agreement by filing a sworn statement, okay, stating his or her reasons that such agreement was obtained through force, intimidation, or violence. So, if there is no repudiation, okay, na ngayon si pangkat or si lupon na magpro-proceed na sila to hearing proper. So, first is kailangan, they need to set the hearing and the parties should be officially notified about the hearing through a notice of hearing and summon. As stated, as you can see on your screen, the KP form number 14. So what if nagkaroon katulad ng sa mediation and conciliation, in arbitration, no, after duly notified or summoned, ay nag-absent siya during the arbitration process and his absence is unreasonable. Then the complaint is outrightly dismissed and the complainant shall be barred from filing action in court katulad ng mediation and arbitration kanina. So if the respondent naman ay absent and yung reason niya is unjustifiable, then the pangkat or the lupon chairperson can issue a certification to file action para i-process na yung charge before the court and certificate to bar the counterclaim in favor of the complainant. So, paano naman kapag pareha silang present, no, during the arbitration process? Ano yung gagawin ni arbitrator? So in here, arbitrator will now conduct a hearing in the same order, no, in a court or in trial. So in arbitration process or hearing, the complainant and the respondent will present the respective case and submit their necessary evidence. And after which, the lupon chairperson or the pangkat will then issue a resolution based on the merits of the case and based on the testimony of the witnesses and evidence presented. So ito na yung tinatawag nating arbitration award na just like and also in arbitration award, just like in amicable settlement, kailangan ma-put din ito in writing, no, in a language or dialect known to the parties and attested by the lupon or the pangkat chairperson. To summarize, okay, the arbitration process are as follows. Number 1, the arbiter orders the secretary to call the case. Step 2, the secretary identifies and enter into record all the appearances of the both parties. Step 3, the parties calls for the complaint or complainant to present his or her case together with evidence. So next, in step 4, when a witness is necessary, he or she is summoned to testify before the proceeding. Step 5, the arbiter calls the respondent to present his or her defense and present evidence and witnesses in the matter or manner afforded to the complaint. So katulad nga na sinabi natin kanina, yung process sa arbitration ay katulad ng court trial or hearing. And last step, after the process or parties have completed their presentation, the case is closed for decision or resolution. So dito nagagawa si arbitrator ng award after niya mapakinggan yung dalawang sides, yung witnesses nila at yung evidence na present nila. And next is after which the lupon or the punong barangay is given 15 days but not later than 6 months from the date of the last hearing to evaluate and issue arbitration award, and after that, another 15 days, or after that, within 5 days, the Secretary shall furnish a copy of the arbitration award to the parties, keep a file to the Lupon office, and be sure a copy to the city, and furnish a copy to the city or municipal court. So, kailan ba titake effect yung decision ni arbitrator? So, sabi ng ating batas, okay, the parties are given 10 days to nullify the decision. So, after 10 days at walang ginawa, the decision of the arbitrator becomes final and executory. So, lastly, award or decision is executed in the manner, okay, mediation or conciliation settlement are executed. So katulad ng sinabi ko kanina, it should be placed into writing in the dialect or language known to the disputing parties. So sa tingin ko, doon nagtatapos ang ating discussion. Thank you for listening, and I hope that you learned a lot from this video presentation. And if you have queries or questions, you may ask me during our virtual discussion in MS Teams, and please be prepared na rin for your presentation and for your activities to be posted and announced on your MS Teams. So good luck and God bless.